thank you all for joining us today for our webinar. My name is Dustin Saldariaga, and I am a senior associate at Scott Legal PC. Today, we'll be spending some time talking about the L-1 visa. We do handle these visas regularly, and they do raise a number of questions. So we're very fortunate today to have Kelly Weiner, who is the managing attorney at Scott Legal, to talk with us and really answer a number of very common questions about the L visa. A few things before we get started. Our firm is a full service immigration firm. So although we do focus on business immigration, we handle family immigration cases, we handle humanitarian cases. So any and all immigration related questions we are very happy to help with. So don't hesitate to reach out. We will be continuing our webinar series by doing at least 2 webinars a month, and we do those on a variety of topics. And we do hope that you'll join us for those future webinars. At the end of this webinar, we'll be sharing with you a link where you can sign up for those future webinars, as well as a link to our YouTube channel where we post our past webinars, as well as shorter videos, again, on a range of immigration topics. As I mentioned, we're fortunate to have Kelly with us today. If you have any questions for Kelly, please do share them either through the chat function on Zoom or through the Q&A box on Zoom. And I will be actively monitoring those and serving as the moderator. I'll either ask them immediately when they come in, or if we're at the time talking about a different topic, I'll save them for the end. But either way, we will get to all of the questions. This webinar is being recorded, and we will share a link to the recording after the webinar. So without further ado, without further delay, Kelly, I will go ahead and dive in to our first question, which is, what is an L-1 visa, and what are the basic requirements for an L-1 visa?
Thank you, Dustin. Good morning, everyone. Yes, so the L-1 visa is an intra-company transferee visa. So what that means is this visa is primarily used to allow companies from abroad, to transfer employees to the United States. So in order to qualify for this visa, there must be a qualifying relationship between the company abroad and the company in the United States. And we'll talk a little bit more about that later. But so there has to be that qualifying corporate relationship. Then both companies have to be actively doing business. So this is defined as the regular, systematic, and continuous provision of goods and services. So both companies actively have to be trading. One caveat to that is that it is also possible to send an L-1 employee to open what we call a new office in the United States. So that's where, if there's not already an actively trading office in the US, there is an ability to still send an L-1 employee to open that new office. However, the company abroad still needs to meet that requirement of doing business. The next requirement is that the actual employee applicant has to have been employed at the company abroad for at least 1 continuous year out of the past 3 years. And the person can't just be in any role. It has to be either an executive, managerial, or specialized knowledge role. And there's very specific, regulatory definitions for each of these, these categories. Then the other requirement is that when they're coming to the United States, they have to be coming to fulfill a managerial, executive, or specialized knowledge role. They do not, however, have to be coming to do the same job that they were doing abroad. It can be a different role, as long as it fits into one of these criteria. And so those are the basic requirements for the L-1 visa.
Perfect. I think my video might have been a little glitchy there. I don't know if
you
all
were doing
saw
some
that.
interesting some interesting things there.
Don't worry, I am okay. So Kelly, let's get to the next question. You mentioned a relationship between the companies. What counts as a qualifying relationship between companies?
Sure. So to qualify for the L-1, there has to be either you're a parent, subsidiary, branch, or affiliate. So let's say that you have a company abroad that owns 100% of the company in the United States. So then there's going to be that subsidiary relationship. The US company is a subsidiary, or the US company can be the parent. You can also have a branch relationship. So in that situation, there's not actually two separate entities. There's kind of one entity, and that can be either in the US or abroad. And you're registering that branch usually in either the US or the foreign company. And then you can also qualify through an affiliate relationship, so where there's common ownership. So that's usually going to look like either a corporate parent that owns each company, or perhaps there's an individual that owns each company, or even a group of individuals that own each company. However, if you have a group of individuals, the ownerships has to be the same proportion for each company that they own.
Perfect. And one of the interesting things about an L-1 is that it can be used to open a new office in the US. What are the additional requirements that would apply for someone wanting to open a new office on an L-1?
Sure. So when you have a new office, you are required to get sufficient physical premises to house the new operation. So this is actually written into the regulations, unfortunately. So even in our new world of remote workplaces, the regulations don't permit people to, just skip over an office altogether for an L1 new office. You actually do have to get that commercial office space, and it should be appropriate to the type of business that you're opening, right? So like if you're opening, let's say like a manufacturing plant, you're going to have to get commercial space that, speaks to that, what the enterprise is that you're opening. If let's say you're opening more of a service-based company and you plan to hire, 4 or 5 employees in year one, then you can get office space. But the office space ideally should be large enough to house all the employees you plan to hire in year one. Beyond the physical premises requirement, you also have to show that the company is going to have the ability to pay the L1 employee and to commence operations in the US. And so what this means usually is that the foreign company needs to have funds to capitalize the US company. These can either be funds that are, kept in the company abroad, but are earmarked, by, corporate resolution for capitalizing the US company, or perhaps the money can also be transferred to the United States, and that's also very helpful. If you're coming over as a manager or executive to open up a new company or a new office, you also have to show that the size of the company is going to support a managerial or executive role within that first year. So the regulatory definitions for what counts as a manager and what counts as an executive are very specific. They really don't want managers and executives doing, ancillary administrative tasks. And so what they want to see is that within that 1-year period, you're hiring people that are actually doing the operational work, that are doing the administrative work, that are doing those ancillary tasks, so that the executive or manager can just focus on those, particular high-level tasks that are assigned to them. If you're coming over to open a new office as a specialized knowledge worker, you still have to show the sufficient physical premises. You still have to show that the company is going to operate, and you also have to show that the company will have the ability to pay the employee. But there's less of a focus than with the L1A, manager or executive, in proving that you're actually going to do aggressive hiring in year one. So if you're coming over for a new office as a manager or executive, generally you need to show, that you've hired sufficient staff by the end of that first year to support the operation. And sometimes, depending on, the size of the operation, that can be a kind of a larger burden on small companies to ensure that they're going to be hiring, a good number of employees in the first year.
Great. And I realize this is probably a good moment to take a little step back and ask, could you describe the difference between an L1A and an L1B visa?
Sure. So the L1A visa is the visa that's used for people coming to the US to work in a managerial or executive role. The L1B is used for people that are coming to the US to work in a specialized knowledge role. And kind of one of the big differences is that executives or managers can kind of renew the L1 visa up to 7 years. And the L1B specialized knowledge workers can only renew up to 5 years. So that's, kind of the main differences between these two visa types.
Perfect. And to return to the topic of opening a new office, how would a new office prove that it meets the requirement of doing business?
Sure. So, for a new office, like if let's say it wasn't a new office, right? Then you're going to have tax returns, you're going to have client invoices, you're going to have all the proof, that the company is actively operating because it is. You're going to have payroll summaries, things like that. For a new office, what they want to see is that you are poised to begin operations shortly. So you're going to provide your corporate formation documents. You're going to provide that commercial, office space that you're required to get. If there's any licenses you need to operate your business, you can submit those. Often a 5-year business plan is going to be really key and very helpful for these kind of new office operations to show that you really have a reasonable plan for hiring and for, earning revenue and things like that. Proof of capitalization is also very helpful. So showing the company has a business bank account and has money in it for those initial startup expenses. And if you have started to get client contracts or memorandums of understanding, statements of work, even letters of intent for future work, those can also be included.
Perfect. Earlier, when you were talking about the requirements, you mentioned that the employee needs to have worked for the company abroad for at least one of the past 3 years. What documents must be submitted to show that?
So generally, you're going to include, the person's pay stubs. Any payroll summaries, anything that kind of outlines the person's name, their salary, it includes their job title. But that's also helpful. In some countries, rather than the pay stubs, they'll have tax returns that actually list the employer name. So some of that is, kind of dependent on which country you're coming from. But that's generally going to be the information that you submit. And then if it's kind of a different employment situation where perhaps the person is, for example, an owner of the company, so they're not a salaried employee, but perhaps they take regular dividends or regular distributions, then you might submit that alternate evidence in that type of situation.
Could you say more about that, about how an owner of a company can qualify for the L1?
Sure. So owners can qualify for an L1. There's just a few extra things to consider. So one is that you actually have to have been working for the company abroad. So just being a passive owner of this company is really not going to be sufficient to qualify for the L1. You need to have kind of proof that you've actually been working for the company. So submitting those distributions can be helpful. Often you want to have, for example, perhaps your second in command, the person who's going to be running that operation while you're in the US, to write a letter confirming the work that you do. So owners can qualify. The other thing that's a little specific about owners is that if you are a majority shareholder, you do have to essentially in your application, submit documentation that shows that your assignment abroad is going to be temporary and you'll eventually be transferred back, to the company abroad to continue working there. The fact that you represent that doesn't necessarily mean that you're foreclosing any ability to get a green card in the future, if that's what you want to do. But it is something that has to be addressed if you are a majority shareholder and coming over as an L1 employee.
Great. Now, a question came in while you were providing that response that provides some details, and without getting into the unique details of this situation, Abdul writes, "We have a business in Canada. We want to expand. Seems like they have several employees. He owns 15% of the company." I think that the question that's more broad is he has an arrangement where he earns equity. And he's curious, is it possible to do an L1A to open a branch in the US with him filling the CEO role in the US? Also, he wonders if employees can be independent contractors.
So I think as long as it's clear, through the evidence, so not just kind of the equity arrangement document, but also, work product like letters, personnel records, as long as it's clear that there was an employment arrangement between the Canadian company and that you were working full time for that company. I think it's okay if the compensation was an equity arrangement. I think, generally the key is going to be showing that you were actually working full time for this company. So if the equity arrangement is different than a salaried employee, that's okay. That's something you can work with because you had this equity arrangement. In terms of the role in the US and the expectation of new employees, can they be contractors? So Potentially, yes. I think, the business model would need to be outlined in the business plan. So as long as kind of the business plan shows that you're going to have contractors that are going to support the office operations and are going to take over all of the work that the executive or manager shouldn't do, I think it's okay if there are some contractors. I would still always recommend that there be some employees. I think you're going to have a really hard time getting an L1, especially for a new office, if you don't actually have proof that you're going to hire some employees to run parts of the operation. So some of that kind of will depend on the type of business that you're in and how well it's outlined in the business plan. I think some contractors are okay, but employees are also going to be good. And perhaps it's not as clear from this question, but something we'll talk a little bit more about later. But sometimes people, like for example, Canada is what we call an E2 treaty country. So sometimes when people are eligible for both an L1 and an E2, kind of look at both options and see, which one works best. So that's, we'll talk a little bit later about kind of the benefits, of the E versus the L.
Great. So how can an applicant prove that they qualify for the executive, managerial, or specialized knowledge role?
Sure. So, to prove that you have, like, we're holding an executive, managerial, or specialized knowledge role, and that you will in the U.S., you're going to submit. So one is going to be kind of a letter, probably from either your direct supervisor or the director of HR, somebody in the company that's in the position to speak to, the job duties that you do. And it should be very detailed, kind of job duties chart that outlines, even with percentages, what you do, and outlines, what the job duty is. Is it executive? Is it managerial? And the purpose is to show that the vast percentage of the work that you do, falls into one of these particular categories. Kind of besides this letter, the other things you can submit are, if you have any personnel records. Work product is also, I think, very helpful. Even things like emails, for example, to be a manager, one of the requirements is that you show you have the authority to hire, fire, promote, assign leave authorization, things like that. And so even kind of internal emails, showing you, kind of exercising this authority over your staff can be very helpful. Organizational charts that outline the job duties of your direct reports can also be very important, particularly for executives or managers. So those are really the types of documents you're going to include to show you meet these regulatory requirements.
And how long can an L1 visa be granted for?
So it's 7 years for the L1A and 5 years for the L1B. And then after you've maxed out that time, you have to be out of the US for at least 1 year before you can try coming back in on this visa category. So then you either, during that time, you have to decide, okay, am I okay leaving and just going back, to my, the country that I came from, or a different country, or do I want to try to transition to either a different visa type or even a more permanent visa, a green card. So during that time, you want to be thinking and planning, because you will eventually run out of time on the L1.
And after that 1 year period, the time frame would restart, so they'd get another 7 and 5 years.
Correct.
Okay.
Correct. Yeah.
Can the L1 employee bring dependents with them to the US?
So yes, they can. They can bring either or both their spouse and any dependent children who are under 21. Their spouse can work in the United States. There was recently a very favorable change for L2 spouses, where they can come into the United States and just based on the I-94 they get, as long as it's stamped L2S for L2 spouse, they can work right away. It used to be the case that they had to apply for a work authorization document, and that that was recently changed. For L2 children, they're allowed to come into the United States, stay here, and can also go to school. But that status doesn't permit them to work in the US.
Great. And a very common question we get, does an L1 visa lead to a green card?
Yes, a very, very common question, very common concern, I think. So like all, of the non-immigrant visas, it doesn't lead to a green card, in the sense that just being on an L1 for some length of time does not mean you're going to automatically have some qualification for a green card. That being said, if while you're here, there's a green card category that is available to you, then yes, you can apply for it. The one that comes up a lot for the L1 is called the EB1C. So this is a green card category that's available for multinational managers and executives. So that means that if you were a manager or executive abroad, and you were there for at least 1 year out of the last 3 years, and you come to the United States, and you're in a managerial or executive role, it may be the case that the EB1C is a good option for you. A lot of the requirements for the L1A and the EB1C are very similar. So that's why people often think that the L1A will automatically lead to a green card. While it's not automatic, if you do meet the L1A requirements, I think it's always worthwhile to see, and you're interested in a green card, it's worthwhile to investigate the EB1C. Things to keep in mind are that the standards for a green card are heightened compared to the standards for a non-immigrant visa. So just because you've qualified for an L1A doesn't necessarily mean you're automatically going to qualify for an EB1C right away. They're going to take, I think, a more stringent look at, what is the size of each operation? Are you really, meeting this regulatory criteria of manager or executive? How many people are you managing? It's not to say that small companies can never have an EB1C. It's just to say that, smaller companies are likely going to receive more scrutiny, and you're going to have to provide more information to show you really meet this criteria. The benefit of an EB1C is that you can avoid what we call the perm labor certification, which we'll talk a little bit about. So this is another green card category that's mostly available to kind of L1, L1B applicants will often go for the perm process. The EB1C, is beneficial because you can file, with proof that you meet these requirements. You file Form I-140, and if your category is current, you can also right away file your green card application, Form I-485. So you can file those together concurrently if the visa is available. And there was just another favorable change where the EB1C category is now eligible for what we call premium processing. So you can get a response on your petition within 45 days of when you submit your application. So this was a very recent change. Previously, premium processing wasn't available for EB1C. And then over the past several months, they've been rolling it out in phases, and now it's available to all EB1C applicants. To switch a little bit to go to the green card question for L1B. So for these people, because they're not a manager or executive, the EB1C is not available for them. However, they can potentially undergo what we call the perm labor certification. This is, the process by which a U.S. company sponsors a foreign worker for a green card. That U.S. company has to get a prevailing wage from the government. They have to test the U.S. labor market, meaning they actually have to place ads. They actually have to review resumes, see if there's anybody qualified, willing, and available in the United States. And if so, the process has to stop. If they do not find any qualified, willing, or available U.S. workers, then they can proceed with the green card application. And then that's when they can file that I-140 and I-485. But first, they have to do that extra step of that perm labor certification, which can take quite a while based on current processing times, which are extremely long, somewhere around a year and a half to even 2 years, just for the first step of that process. So the other thing to consider is that while these may be the two most common green card processes for L1A and L1B, as I mentioned, if there's another category that's available to you, you can also investigate that. Green cards are available through various mechanisms, including investment, employment, family, and humanitarian. So always good to consider all your options.
Great. Abdul has another question, a good one. Does the L1 visa holder need to live in the US for a certain period of time, or would it be okay for them to continue to live in Canada and occasionally come into the US on an L1?
That's fine. There's no requirement that you live in the United States. There's even something called an L1 commuter visa status. And that's where if you're spending more than 50% of your time outside of the United States, you can even kind of get past this, 7-year visa expiration because you're spending so much time out of the United States. You can continue to renew your visa even beyond the 7 years, as long as you can provide that documentation, that travel history, things like that, that show that you've been out of the United States for at least 50% of the year.
Very interesting. Would that be an annotation on the visa? It'd be an L1A just annotated, or?
I don't know if they annotate the visas as commuter. I think sometimes they do, sometimes they don't, because you're dealing usually for this, it's with Canadians and you're dealing with, Customs and Border Patrol. So it's whatever they write in your passport. So I think usually not, but it's something that you would deal with, when you go back to renew your visa, you would have to provide that travel history to say, well, even though I've been here for this long, I'm on a commuter visa, and here's my travel records that prove that I meet this requirement.
Perfect. Now, Kelly, you referred before to the E2 visa, which our firm handles very frequently. Abdul had mentioned that he's a national of Canada, which is an E2 treaty country. So could you talk a bit about how you approach, this question of whether an E2 might be a more favorable alternative to an L1?
Sure, absolutely. So I think there's kind of different advantages to each visa category. So the first consideration obviously is, is the company in the United States that's going to be opened, is it going to qualify as a treaty country? So, in this case, where someone's a Canadian, they can, qualify because it's a treaty country. And the company in the US would need to be at least 50% or more owned by Canadian nationals. I think one, kind of downside to the E compared to the L is that the E2 always requires investment. It's a treaty investor visa. You have to invest a certain amount of money in order to get this visa. That being said, if let's say someone wants to open up a new office in the United States, the benefit of the E2 for someone like a Canadian national is they can get a visa that's a 5-year visa. So that really gives you a big runway to kind of get that company where you need to go to ramp up operations, to get revenues stable, to get profits stable, to hire employees. Versus if you're opening up a new office and you're going with an L1, you only have a 1-year runway to prove that this company is going to support an executive or managerial role. And that can be quite tough. So I think if it's kind of a new office and there's an option to go E2 or L, I think E2 is generally going to be more favorable because it gives you that extra time. And the L, there's a benefit that really no investment is required, not in the same way there is for an E2 where you're required to make a substantial investment. That being said, again, if it's an L1 new office, you do have to show that you're able to capitalize the company. So there should be some amount of cash flow. But it's different than the E2 investor visa where you have to put money at risk. For the L1, you can just show you have cash in a bank account to support operational needs, and that's fine. Another consideration, for L1 or E2 is what is the person's long-term plan? Do they want to get a green card? If they do want to get a green card, the benefit of the L1 is it's what we call a dual intent visa. So while you're on the L1, if you're applying for a green card, you never have to worry about travel in and out. Even after your adjustment of status application is filed, you can still travel on your L1 visa as long as you meet certain criteria and are coming back to work for the same employer. So the L1 gives you a bit more flexibility if you're applying for a green card. That being said, again, at 5 or 7 years, you run out of time. Unless you're an L1 commuter. For the E2, you can get your visa, and then as long as the company continues to run, you continue to have employees, the company continues to be owned at least 50% by treaty country nationals, you can continue to renew that visa indefinitely. So it really kind of depends on the person's, particular goals. But I think very often, when we have E2 or L options, we are pushing people towards the E2. A few different reasons. One is that for the L1, you have to get an approval. Not for Canadians. Canadians are special. We'll talk about them. But for most people, you have to go to USCIS first, get an approval, and then you can go to the consulate and get a visa stamp. So there's that 2-step process. Canadians just go to the border for their first L, and then after that, they have to go through the 2-step process. For the E2, you're just submitting directly to the consulate, or if you're in the United States, you can just submit directly to USCIS, and it's a one-step process to get that that response. So, I think there's always going to be kind of competing interests, but I think just the very often the E2 is going to be if someone's opening up a new business in the United States, the E2 is going to be more favorable, just because you can get that visa for longer. Additionally, the L1. Again, not for Canadians, but for others, very often you're going to get what we call a request for evidence. And they can be very strict about who qualifies as an executive, who qualifies as a manager. I think L1s have an RFE, request for evidence rate of almost 50% and have for this past several years. So, the E2, I think they can sometimes take, a less strict approach on some of the criteria. So that may be more favorable as well.
Great. And I just want to say to the participants on this webinar, please do send in any other questions you have. We are nearing the end of the presentation, and I want to make sure we answer any questions you have. Kelly, just to go back to something that you described, but I think it's helpful to just flesh it out a little bit more. The application process for an L1 for a Canadian versus someone who is not a Canadian. What's the process like for Canadians? And then what is it like for those who are not nationals of Canada, both at the initial phase and then to renew the visa?
Sure. So for Canadian nationals, they have the benefit of being able to go get their initial L1 approval at the border. So for them, what that's going to look like is they're literally going to take, the package of information that's prepared, with their attorney or that they've prepared, and they're going to go. There are some ports of entry that are optimized. It's usually better to use one of those, and literally just have an interview with the border official right there. The border official will either approve, or deny the visa. If they approve it, they will stamp the L1 in the Canadian person's passport, and then they'll send the application to USCIS. And then after the fact, USCIS will issue an approval notice that gets sent to the company. For somebody who's not a Canadian, what they'll have to do is first that application gets submitted to U.S. Citizenship and Immigration Services in the United States. U.S. Citizenship and Immigration Services will assess it. Very often they'll issue a request for evidence, or about 50% of the time. And then if they approve it, then the person, if they're outside the U.S., can take that approval notice, go to a U.S. consulate or embassy, and get the L1 visa stamp in their passport and enter the United States. The renewal process. Let's say somebody's already in the United States, you could submit an extension of status with U.S. Citizenship and Immigration Services. If they're outside the U.S., you're still going to submit with U.S. Citizenship and Immigration Services, but they'll just go abroad and get a visa stamp. And then for Canadians, unfortunately, they're no longer able to renew their L1s at the border. For many, many years they could, and then in recent years there was a change, and now they are required to submit those renewal applications through USCIS, the same as others.
Very interesting. Well, Kelly, that brings us to the end of our presentation. I do want to thank you for sharing your expertise with us today. For those of you who are participating on the webinar, we will be reaching out to you with more information on future webinars, and we hope to see you there. If we can be of any assistance, please don't hesitate to schedule a consultation with us. We're always happy to help. So Kelly, thank you. And to our participants, thank you for joining us. Have a great day.
Thank you.